Who is going to lose the 2000 election? One possible loser will be the United States Supreme Court. If the United States Supreme Court is subject to court packing, or if Judge Barrett decides to sit on an election case and cast the deciding vote in favor of a president who nominated her, the loser may be the United States Supreme Court. And if the Supreme Court loses, we all lose. You're going to hear why on The Durst Show. The nomination of Amy Coney Barrett and the quick confirmation process that Republicans are pushing through in order to have her seated in time for the election raises real questions about the future of the Supreme Court, its credibility, and its integrity. And this morning on The Durst Show, I want to discuss two of those challenges to the continued integrity and credibility of the Supreme Court. The first is whether or not the Democrats will carry out the threat that some have put forward that if Judge Barrett is confirmed, they will respond by packing the court if they get a majority of the Senate and the majority of the House. And the second is whether or not Judge Barrett, if she's confirmed, as likely she will be, should recuse herself if an election case comes before the court involving the continuing presidency of the man who put her on the Supreme Court, namely President Donald Trump. Those are both issues that I believe threaten the credibility and integrity of the Supreme Court. Let's start with the issue of court packing. Just yesterday, another senator, Senator Chris Coons of Delaware, who's very close to Vice President Joe Biden, who's running for president, said that he's an open mind about whether to pack the court. Let's wait and see. He may, in the end, be in favor of court packing, depending on how the Barrett nomination goes through. And we know how it's going to go through. The Judiciary Committee is going to vote on along partisan lines to send it to the floor, and the Senate along partisan lines is probably going to vote to confirm her, and she will be sworn in to serve on the Supreme Court probably before Election Day. So that, again, imagine the hypothetical scenario. It's hypothetical. We don't know. None of us has crystal balls. Polls are not 100% accurate. But let's assume that Biden's elected president. Let's assume that the Senate is taken over by the Democrats, say 51-49 or 52-48, and the House remains in the hands of the Democrats. There's absolutely no doubt that if that happens, there will be enormous pressure from radical Democrats, from the OAC group, from others, to pack the court, to pass legislation, which Congress can do, to pass legislation that would expand the number of justices from 9 to 11 or 9 to 13 and allow the sitting president, who would then be, according to this hypothetical, Joe Biden, to nominate and the Senate to confirm 2 more or perhaps 4 more justices to the Supreme Court. Now, there is one small barrier to that happening, but it may only be a small barrier. At the moment, the filibuster and the cloture rules still apply to legislation. And so if 41 senators said no to court packing, even if you had 59 in favor, that wouldn't be enough. You'd need to do one of 2 things. Either you'd need to get enough senators to give them the 60 votes they need to impose cloture and end the filibuster, or by a majority vote, and this is what's ironic, by a majority vote you can end the filibuster and cloture rules, which they did for appellate court judges, district court judges, and then ultimately Supreme Court justices. So it would be a 2-step process. First, they would have to end the filibuster and cloture, because there's no way that Republicans are going to get 60 senators. That's just not going to happen. They may get, 52, 53, maybe 54, unlikely 55. Maybe they won't even control the Senate. We don't know. But they're not going to get 60. And so you'd need a clean sweep of all the Democratic senators, which is not assured. There are going to be some senators from the Democratic side who won't go along with court packing, just as some Democrats didn't go along with court packing when Franklin Delano Roosevelt, who was one of the most popular Democratic presidents in history, proposed it in the late 1930s. So my own view is that it's going to be a tough sell. It's going to be a tough sell. And I think that Vice President Biden will understand that. But even if it were to pass the Senate and the House, it would have to pass through the president. The president gets to veto that law. It's a law like any other law, expanding the number of justices, just like Medicare, just like Affordable Care, just like any other statute. And it becomes the law if the president doesn't veto it. Would a President Biden veto a court packing plan? My guess, yes. My certainty, no. His heart would not be in court packing. I think he would understand that it would be the beginning of an arms race, because if the Republicans took control of the House, the Senate, and the presidency, they would then raise the number from 13 to 15 to 17, however many it was necessary for them to get to stack the court with their nominees who would vote in favor of their ideology and their politics. And it's a never-ending cycle. Once we get off 9, there's no limit. We can get from 9 to 19 fairly easily in an arms race that would take 15, 20, 25 years, a relatively short term in the history of the United States and the history of the Supreme Court that has served us very well since 1790 something. So in the end, I don't think we're going to see court packing. I think we're going to see the threat of court packing. We may see a vote on court packing. We may see the end of the filibuster. The Democrats have threatened that for a long time. Let's talk about the filibuster for 1 minute. The filibuster was used very badly by senators from the South for many years to prevent civil rights laws from being passed. So I grew up hating the filibuster and always pleased when the filibuster was abolished, because after all, filibuster is anti-democratic. It allows people to read from telephone books forever and ever, and they can't be shut down unless there's 60 votes. But sometimes the filibuster serves a useful purpose. It serves a useful purpose to correct the errors of the Founding Fathers. The Founding Fathers should never have allowed Supreme Court nominations to be confirmed by a majority vote. They should have required a 2/3 vote, because that would have incentivized presidents to nominate candidates who have the support of both parties, centrist candidates, consensus candidates, candidates who are less ideological. But the framers made a mistake. They had a simple majority, and the Senate, in its wisdom, tried to correct that mistake by having a filibuster and a cloture rule that applied to Supreme Court justices and other judges. That got abolished. Democrats abolished the filibuster for other judges, and the Republicans abolished it for Supreme Court justices. And now, if there is a move toward court packing, we may see it abolished for all legislation, or maybe it would be limited to legislation affecting the number of judges. It would be hard to frame that, but it's certainly possible. So I think it would be a mistake to pack the court. I think it would be a mistake for Democrats to seek to pack the court. But believe me, there are radicals in the Democratic Party who don't care about long term. They care about today. They know the truth. They know what's right. Why do we have to have process? Why do we have to follow tradition? We're the new Democrats. We know everything. You're going to see a lot of that from the radicals in the Democratic Party. I think a lot of us at the center, whether we're Republicans or Democrats, were pleased to see Joe Biden beat out Bernie Sanders, because that moved the Democrats more to the center. He was nominated, I think, because of his centrism. And there are many who hope that his centrism will move him away from the radical approach to court packing that some on the left will advocate. So you heard it here. We're not going to have court packing. I don't believe in the end it will succeed. I think cooler minds will prevail. I think the filibuster cloture rule may well stay in effect. That I'm not so sure of, but I hope that for some purposes it does. And then I think President Biden, if he were to become president, I think would veto a court packing plan if it could get a majority of the House and the Senate. It could get a majority of the House pretty easily. Majority of the Senate is going to be a little harder. So if you're going to vote based on court packing I don't think it's a basis for casting a vote against Democrats. There may be other reasons for it. And again, here you're not going to hear politics. You're going to hear analysis. That's not a good reason for casting a vote against Democrats, because I think it's highly unlikely we're going to see court packing, certainly during a Biden administration, if there were to be a Biden administration. Now, one of the reasons that there is a movement for court packing is that Judge Barrett may very well have been appointed to the Supreme Court for purposes of giving the president a fifth vote in the event the election comes before the United States Supreme Court. That's not my view. That was the president's view. He said he wanted the nomination to be confirmed by the Senate in time for the election, so that if a case came to the Supreme Court, it wouldn't be 4-4, it would be 5-4. A lot of people, Republicans and Democrats, will worry if the deciding vote was cast by a nominee of the president just 3 weeks before the election, who the president said he wanted confirmed in order for her to cast the deciding vote. Would Judge Barrett herself be biased or prejudiced? I can't get into her mind. I can't psychoanalyze her. She struck me as a very honorable person. I don't think at a conscious level she would be influenced by that. Certainly she has said, and I believe her absolutely, that no deal was made, that nobody even mentioned to her the need for her to vote for the president. That would be foolish, and it didn't happen. But there is a case decided by the Supreme Court some years ago in which the court said not only is the actual prejudice a basis for recusal as a matter of constitutional law, they said as a matter of constitutional law, the likelihood of bias. This was a case where a judge was running in, I think, West Virginia, and a litigant had contributed massively to the judge's campaign, and the judge didn't recuse himself and then cast the deciding vote in favor of the litigant. The Supreme Court said no, the Constitution requires recusal when there is a likelihood of bias, even if there isn't a certainty of bias. Also, the rules of the federal statutes say that the appearance of bias is enough. If an average person in the public would believe reasonably, maybe not correctly, but reasonably, that bias was at play, that too is a ground for recusal. That's not constitutional, that's statutory, and that's not binding on the Supreme Court. Unfortunately, the rules of ethics, the statutory rules of ethics, the Judicial Code of Conduct is not applicable to the Supreme Court in the sense that the Supreme Court doesn't get to decide as a body whether or not one of its justices should be recused. That's up to the individual justice. And Judge Barrett has said, invoking the Ginsburg rule, no hint, no prediction. I'm not going to tell you anything about whether I will recuse myself if there's a case coming to the Supreme Court about the presidential election. She's refused to say whether she would recuse herself. She did pledge that she would take into consideration current law on recusal. Well, current law seems to suggest that probably she should recuse herself. There is the possibility of bias. There is the potential appearance of bias. It could definitely affect the credibility of the Supreme Court. Just imagine the following scenario. Imagine, again, this is just a hypothetical scenario. I'm a law professor. I get to create hypotheticals. This is not such an unrealistic hypothetical. Imagine that Vice President Biden wins the popular vote pretty decisively, as Hillary Clinton did in 2016, and that there's a very close race on the Electoral College, much like there was in 2000, where Florida decided the presidency because of its many votes in the Electoral College. And let's assume it comes down again to 1, 2, or 3 states, Florida, Pennsylvania, Michigan, Ohio, and let's assume there are real issues about write-in ballots, about mail-in ballots. And we get to a Bush versus Gore situation where people are counting chads and counting ballots and looking to see whether or not the postmark was the right date or the wrong date. And we get into one of those real messes, which I think every American should hope we don't get into. But then the case gets to the United States Supreme Court, and it's 4-4 without Judge Barrett, and the lower court voted against President Trump. So if the case goes 4-4, Trump loses. But if Barrett sits on the case and she casts a vote for Trump, he wins. And imagine that she then decides not to recuse herself, and she casts the deciding vote 5-4, making Trump the president of the United States once again. Again, not getting into politics. Is that good? Is that bad? You all should vote. That's your decision. That's up to the electors. I'm making an analysis now. Assuming that were to happen, I don't think that every Democrat would accept it the way they did in 2000. In 2000, there was a lot of grumbling. I wrote a book called Supreme Injustice. I railed against my friends on the Supreme Court. Antonin Scalia was furious at me. We had fights and arguments. We remained friends because back in those days, you can remain friends with people when you disagreed with them and argued with them, unlike today. But I wrote very strongly. I said that Justice Scalia had violated his oath of office because his oath of office required that you not consider the individual when you cast your vote as a judge or a justice, that individual or political preferences are not allowed to play any role. And I wrote in my book, I thought that if the shoe were on the other foot, that's where I first came up with that concept. If the shoe were on the other foot, if it weren't Bush versus Gore, if it were Gore versus Bush, if in fact Gore had won the Florida vote by a small number and it were Bush that were trying to get a recount, I myself was personally convinced, whether consciously or unconsciously, that Justice Scalia and the other four justices, O'Connor and some of the others, would have voted the other way. They certainly would have invented an equal protection argument, never before used, never since used, to justify ending the count. Nonetheless, and despite my book, which became a bestseller, despite my book, the American public accepted the outcome. Why? Because Al Gore got on television and said, I'm not going to contest this. I accept the outcome. Gore was furious. I know. He was very angry. He really thought the election was taken from him. But he, like Richard Nixon, who thought the 1960 election was stolen from him by John F. Kennedy, accepted the election. Would President Trump accept the election? Would Republicans accept the election? Would the Democrats accept the election if the opposite happened and if Justice Barrett were to cast the deciding vote? We don't know the answer to that question, and that could produce a constitutional crisis and indeed a political crisis in America if Judge Barrett would have cast the deciding vote that made President Trump the president again. I believe, I don't support, I believe that people would take to the streets. I believe there would be violence. I believe there would be riots. I believe we would have civil disorder. Would the opposite happen if President Trump wouldn't accept the outcome of the election? Maybe. I don't want it to happen on either side. I would like to see a decisive election. Go out and vote. Make sure you vote. Make it decisive. Keep it from the Supreme Court. It would be a disaster to have this case go back to the Supreme Court. So my hope is that on Tuesday night at 11 o'clock a night, we know who the President of the United States is, that the vote is decisive and overwhelming on one side or the other. I'm not making a political judgment here again. One side or the other. Keep the case from the courts. The integrity of the Supreme Court is more important than who wins this particular election. So you've heard my analysis. I'm not going to tell you who I'm voting for. I'm not going to tell you who to vote for. That's your decision. But you heard my analysis. You'll always hear careful, thoughtful, objective, nonpartisan analysis on The Durst Show, and you'll never be bored. Now it's time to hear from you, the listeners. Today we have lots of calls from interested callers. Our first call is from Burbank.
Amy Barrett may seem to be rushed, but President Trump actually announced her name as a potential nominee in November of 2017, so it's almost 2 years. Do you think that's a good idea to announce it in a list of nominees in advance? And would you urge Joe Biden to do so? Thanks.
I myself think it's a bad idea to announce the list of nominees before an election because that gives too much influence to radicals in the party on who is on the list. So I'm pleased that Joe Biden has not put forward a list. Judge Barrett was on the short list of nominees who eventually, for the seat that eventually went to Judge Kavanaugh. So her name was on that list back several years ago, but just among many other nominees. She first got nominated just a few weeks ago, and the confirmation process just recently began. So I do think it is something of a rush. I think there ought to be a rule that the Senate establishes for candidates from both sides, saying that no nominee will be considered after the political conventions end, which is mid-August, and any vacancy that occurs after mid-August should be filled after the election. I think that would be a good rule, but it's not the rule today. And so today the issue is whether the same standards should apply to Judge Barrett as the Republicans applied to Merrick Garland. Under that principle, this nomination should not be rushed forward. Peter from Germany.
Reunited Germany continues to pay for the crimes of National Socialism. My question is, would restitution and or compensation serve justice for the crimes committed during American slavery? Keep up the great work. Thanks.
Thank you. What a very interesting question from Germany. As we know, Germany did pay reparations. You can't ever pay reparations for the loss of 6 million people. How are you going to have reparations for the fact that we don't have a cure for cancer or heart disease or many of the most serious illnesses in the world? How can we be sure that the cures for those diseases didn't go up in smoke in Auschwitz when 6 million people, including some of the most brilliant scientists, doctors, innovators in the world, were murdered by the Germans along with ordinary folks? 50 million people killed in the Second World War, all as the result of German aggression. There's no way of ever compensating for that, but the Germans at least have made an effort. I do believe in reparations. What form they should take is very difficult. Originally, we promised freed slaves 40 acres and a mule. We didn't do it. We also promised Native Americans under various treaties material advantages. The Supreme Court upheld them. And President Andrew Jackson infamously said, John Marshall, the Chief Justice, ordered this, let him enforce it. We just failed to follow the law. We've been a lawless country for many years. I do not believe that we are a systemically racist country. I don't accept that. We have made enormous progress since I was a young civil rights activist in the 1960s and went down south in the 1960s. We've made enormous progress in voting and equality and affirmative action, etc. But there's still residual racism, not systemic, but residual racism. And I think we should figure out a way of at least acknowledging that through a form of compensation. We did it symbolically for Japanese Americans who we interned in detention centers after Pearl Harbor. We acknowledge that. I helped Justice Goldberg, who was then a private citizen, draft a statute which gave every family that was detained a symbolic small amount of money. I think it was $25,000. But at least it recognized the sin that we had committed against Japanese Americans. We have to acknowledge the much greater sin we committed against African Americans. The form that reparations should take is very difficult because many blacks in this country are not descendants of American slaves. It's been a long time, and not every African American person who is a descendant needs financial reparation. The structure of how reparations would work is not easy, but it's certainly something morally that we should very seriously consider. Thanks for your great question. Okay, Bob from Maryland, what's your point?
Would you ever represent a client knowing he is guilty but fighting to let him go without punishment? Also, how does the O.J. Simpson case pertain to this question? Didn't all the factors and evidence point to his guilt, and yet he still went free? Thank you so much.
That's a great question. I wish John Adams were alive so you could ask him that question. John Adams, of course, represented the people who conducted the Boston Massacre, British soldiers Can you imagine anybody more unpopular in Boston than British soldiers who had gunned down Crispus Attucks and so many other American patriots, and yet John Adams stood and defended them. Abraham Lincoln defended guilty people. Clarence Darrow defended guilty people, including guilty murderers, Leopold and Loeb. So the answer to your question is yes, I would and have defended people I believed were guilty. Sometimes I'm surprised. I can tell you only about one case because I've written about it with the permission of the defendant. When I first took the Klaus von Bülow case, remember that case? He was accused of injecting his wife with insulin and causing her a coma from which she ultimately died. I thought he was probably guilty. And once I did the research on the case, put together my team of students, we all came to the conclusion that he was innocent, that she had died of self-inflicted abusive behavior that she had undertaken, and pharmaceuticals and others, and that he was not guilty. I've had that in other cases as well. I've had the opposite, cases where I started out believing the defendant was innocent and turned out to be guilty. The important point is I'm not the judge. I'm the advocate. I'm the zealous advocate who will argue against prosecuting and punishing the person. Sometimes you think they're guilty of something much less serious than they turn out to be guilty of. Jeffrey Epstein, when I first agreed to be his lawyer, he was only charged with a couple of cases of having massages from young girls who he believed were over 18 and turned out to be 17 and a half. Well, it turned out to be much worse than that. I didn't know that at the time. Once you take a case, you don't quit. You stay on the case. As to O.J. Simpson, I'll tell you a funny story about why I can't answer that question. When Benjamin Netanyahu was elected Prime Minister of Israel, he invited me into his office to just talk to him. I'd known him when he was a student at MIT, and he took me aside and said, Alan, there's something I've always wanted to ask you. Did O.J. Simpson do it? And I said, Mr. Prime Minister, there's something I've always wanted to ask you. Does Israel have nuclear weapons? He said, you know I can't tell you that. I said, Mr. Prime Minister, you know I can't tell you that. I can't tell you whether I think O.J. Simpson did it or didn't do it, just like you can't tell me whether Israel has nuclear weapons. We all have secrets that ethics and law require us to keep, and whether or not a particular client was guilty is one of those secrets. So sorry, not going to tell you. Our next call is from Texas.
With all these discussions about court packing, my question today is, if the court is packed and then the party in power makes it harder to unpack, how exactly could unpacking take place? And also, if perchance the Senate, the House, the presidency, and say hypothetically the majority of the court is left-leaning or at least Democrat-friendly, and if they decide to target a president, that president will have no recourse, as every avenue would be controlled by an opposing entity. Isn't this a flaw in the system? And if you were a lawyer, how would you take care of this situation? Thank you.
Great question. I could teach a whole seminar on the complexity of the questions you've asked. First, yes, Congress could unpack the court. Let's assume the Democrats were to pack the court and have 11 justices. When the Republicans came in, they could have a vote and reduce the number to 9, but it would be for the future. You couldn't take a sitting justice off the Supreme Court because the Supreme Court justices are appointed for life during good behavior. So you could unpack for the future, but you couldn't unpack the particular court. If a court became partisan on one side or the other, it would lose a lot of its credibility. But you're absolutely right. It could, if you had all three branches, or the legislative branch and the judicial branch, turn against the president. Yeah, that's why we have checks and balances. We hope that the checks and balances work fairly, but it's easy to imagine that they wouldn't. The worst scenario is you have all three branches, the whole legislative branch, the executive branch, and the judicial branch, in the hands of one ideology or one party, and then there's no check and balance to protect the people. That's what happened obviously in Nazi Germany and other authoritarian and totalitarian countries. Everything is controlled by the same ideology. I argued cases in the Soviet Union. And in the Soviet Union, they say marriages may be made in heaven, but sentences are made in the Kremlin. And, we had cases where we knew our clients were innocent, but we knew the Kremlin had decided that they had to serve time. Natan Sharansky, one of my favorite clients, served 7 or 8 years in prison because the Kremlin wanted him to. And the law was clearly on his side. The facts were on his side, and ultimately we got him out. But he had to serve a considerable period of time before he got out because the Kremlin wanted it. I don't think we ever want to see our country under the domination of one party, one ideology, one person. That's what we fought a revolution against. Our next call is from Harvey in Henderson. You're a repeat caller. I love repeat callers. Keep calling in. Harvey, what's your point?
Good morning. Thank you for this morning's excellent podcast. However, Facebook and Twitter should have gotten in touch with the Biden camp and told them Hunter had 2 hours to respond to that New York Post story. If he didn't clearly state that he never took his laptop to that store for repair, that the original emails that have been disclosed to date are totally bogus and made up, they were not his, and that the entire story is bogus, then Facebook and Twitter had an obligation to run that story. How many stories have they run about Trump that have previously been thought to be accurate and truthful and turned out to be total fraud? And like you say about you, they run phony stories about you. If Facebook and Twitter are going to cherry pick what they believe is true and what they believe is false, we're done. Thank you. Have a great day.
Thanks for a great question. I tend to agree with you. I think that Facebook and Twitter either have to allow everything to go on or they have to have transparent standards. I also agree with you that the Post should have called the Biden camp and Hunter Biden, if they could reach him, and say, we're going to go to press in 2 hours, 4 hours, 8 hours. If you tell us that it's not your computer or it's fake or you didn't send those emails, obviously we will have to do further checking. If you tell us it is legitimate, we will report the story. And if you refuse to comment, we'll print the story and print your refusal to comment. I don't know whether that was done. I do know that several Post reporters who reported on the story refused to have their bylines on the story because they didn't think the Post had done a sufficient job of checking. But whether the Post did a sufficient job of checking is a journalistic issue up to the Post. Twitter and Facebook that publish virtually anything other than child pornography, a few other excluded categories, should have published, should have allowed retweeting, should have allowed their general rules, should have allowed the marketplace of ideas to operate. I don't believe in selective censorship based on ideology or politics. So you have a point. In a future show, I think we're going to talk about the Internet Protection Acts like Section 230, which give the platforms complete immunity from publishing known lies and known defamations. And we'll ask the question whether that goes too far or whether that's made necessary by the spirit and letter of the First Amendment. But for now, I too join your criticism of Twitter and Facebook for applying a non-transparent, apparent double standard. Our next caller comes from Maryland.
Hi, my name is Shuli. I'm from Silver Spring. I want to tell you that I'm a big fan of the podcast. I really appreciate your thoughtful perspective and the historical context that you always provide in your commentary. My question is about how concerned the American public should be about voting inefficiencies and even voting fraud. A lot of people are talking about how they've gotten multiple ballots for addresses where they didn't live for the last 30 years and yet they're getting a ballot there, or there's ballots that exist for deceased people, or even people who are concerned about voter fraud, like the poll workers rigging ballots or not counting their ballot. Is this an actual phenomenon or is it just hype? Is this something people should be worried about? And if that's the case, what should we do about it? Thank you.
It's a great question. We're getting hype from both sides of this issue. We're getting the Democrats saying there is absolutely no risk of voter fraud or voter mistake. Nonsense. Nonsense. Of course there's some risk. Then we're getting from the Republican side, oh, there's overwhelming risk. There's going to be massive voter fraud. Nonsense. There's not going to be massive voter fraud. The answer is the kind of answer you never get in America today. A nuanced discussion. There's going to be some mistakes. There were mistakes even in 2000. We know that. There are going to be some instances of fraud, probably not a great many, and many, many more legitimate votes will be cast because of mail-in ballots than would have been cast had we required everybody to go to the polls. It's going to be a balance. The Democrats are fooling you. The Republicans are conning you. They're both dead wrong. There will be some voter fraud. There will be some voter mistake. But on balance, the number of true ballots will so overwhelm the number of fraudulent or false ballots that on balance, it's a good thing to have vote by mail. But don't believe the extremes on either side. They have agendas. They're trying to fool you. They're trying to scare you. They're trying to con you. Believe the truth. Remember, the truth almost always is somewhere in between what you hear from the Republicans and what you hear from the Democrats. Don't trust politicians. Learn the facts. Believe in science. Understand the realities. And the realities are, yes, there will be some fraud. Yes, there will be some mistakes. And the vast majority of ballots cast by mail will be legitimate. And on balance, it's better to have a little fraud and a few mistakes rather than deny massive numbers of people the right to vote. Look, I think of myself. Since 1960, I've gone to the polls every single year to vote. I brought my kids to the polls. I love voting. I love meeting my neighbors. I love seeing the signs. It's the best day of the year when people go and vote in America. Wow, this year I'm not going to vote by polls. I'm going to vote by mail because I'm 82 years old. I don't want to catch coronavirus, so I'm going to vote by mail. And don't tell me I can't vote by mail because maybe somebody somewhere else will have a fraudulent ballot. Stop the fraud. Address the fraud. Get to the fraud. But let people like me and others vote by mail because on balance, voting by mail will produce far, far more valid ballots than fraudulent ballots. Chris from San Diego, what's your question?
A case about the use of census data to determine representation is being taken up by the Supreme Court. What, if anything, does the Constitution or legal precedent tell us about including or excluding immigrants from making this determination? Let me know. Thanks.
It's a good question. The Constitution is absolutely silent about that. Ironically, the Constitution does talk about how you count slaves and non-citizens who were enslaved people. They were 3/5 of a human being for purposes of counting, but it doesn't speak about people who are in the country either as lawful immigrants or unlawful immigrants. That's going to be statutorily determined by the legislature and then by census. There's no constitutional right for an illegal immigrant to be counted. There isn't even a constitutional right for a lawful immigrant to be counted. That's, again, a matter of statutory law and statutory interpretation. So, there are good reasons for counting everybody, but the legislature has a right to say only citizens get counted. Hey, Abe from Texas, what's your question?
I spoke last podcast about Facebook and Twitter. Can you explain what is the Section 230 law and whether it should be removed because of situations like this? Thank you for your awesome podcast.
Great question. 230 was inserted into federal statutes early on in the internet age before we really saw the social media come to real maturity. And it provides that if you're a platform, if you're just a platform that allows people to come on and write whatever they want or say whatever they want, you're not like the New York Times. You're not a publisher. It distinguishes between a platform and a publisher. A platform is like a taxi cab. You can't refuse to take a taxi rider. Say somebody says, taxi, taxi, I want to go vote Republican. The taxi driver can't say, no, I'm only taking Democrats. Taxi drivers have no discretion. You have to take anybody to where they want to go as long as they can pay the fee. So that's what platforms are supposed to do. Publishers, on the other hand, I write a letter to the New York Times or an op-ed, they have a right to publish or not to publish. They have a right to publish accusations against politicians or not to publish. So that was the distinction that was made by Section 230. But now we're seeing platforms become publishers. We're seeing platforms making decisions what to publish, what not to publish, or how to publish them, and how widely to disseminate them. Again, the Hunter Biden issue with the Twitter and Facebook is a perfect example. They decided to become publishers, not just platforms, when it came to that issue. And once you become a publisher rather than a platform, you may not be subject to the exemptions of 230. And I suspect that we're going to see Section 230 revised in the years to come to create a more nuanced distinction, because we're seeing overlap now between platforms and publishers. These are the great free speech and First Amendment issues of the 21st century. The framers of our Constitution, when they wrote the First Amendment, of course had no idea what social media would become, and we have to now deal with issues of free speech in the context of a very different media than the media that existed when Tom Paine wrote Common Sense. So we're going to have to watch very carefully on this show and in general how the media is treated by legislation and by the First Amendment. Ultimately, we're the ones who are supposed to be protected by the First Amendment, not big giant corporations. And so let's see how that works out. Great question. Great questions today. Today was really a treat. Lots of really excellent questions. I'd love to get more questions from you, repeat questions, comments, observations. As I promised you, you're never going to be bored on the Durst Show. You're never going to be bored by the questions, and you're not going to be bored by my answers. So see you again soon on the Durst Show. An important part of the Durst Show is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Durst Show.